All right, I believe you should be good to go.
David, do you want to start with the conflict?
Yes. Uh, Afternoon, everybody. This is a subcommittee meeting on inquiry of the DRC. The members of the committee are reminded of their obligations under the North Carolina Ethics Act to avoid any conflicts or the appearances of conflict. Does anyone have anything they wish to report or need to report to us on the conflict situation at this time? If not, if you see something arise during the meeting or you become aware of something as we move forward, please let us know, and we will note that. Nicole, can you tell us who all is present with us today, please?
So yes, we have subcommittee members Fran Muse, William, Bill Rogers, Wade Harrison. Elizabeth Johnson is not here. And then participating as a guest is Tara Kozlowski from the DRC. And then our officers, Marcy Armstrong and Todd Brown.
Great, thank you. Welcome, everybody. I know we have one, I think I saw an email from Fran, I believe, that said we might be losing you at the bottom of the hour. Understand that. That's just one of those things that happens for all of us. So we'll plunge right in. Nicole, can you set the table for us, please?
Yes, I'd be happy to. So you may recall that at the April meeting, the Ethics Committee voted to publish this opinion for comment. But prior to publication, we shared the opinion with Ms. Kozlowski, and she made some suggested revisions to the opinion. So we brought it back. The staff agrees that we needed to make some revisions. And then at the July meeting, we recommended that this opinion be assigned to a subcommittee for further study. So you have the materials about the proposed opinion. It addresses the professional responsibilities of a lawyer who is serving as a mediator when the parties to the mediation and their lawyers to the mediation want to include a clause in the settlement agreement that no one participating in the mediation process will file a grievance against any of the lawyers. So the proposed opinion first reminds lawyers about the reporting. Lawyer misconduct is a cornerstone of our self-regulation. It's how we self-regulate. And under our rule, 8.3, lawyers have a professional obligation to report another lawyer when they know that another lawyer has engaged in misconduct that raises a substantial question as to that lawyer's honesty, trustworthiness, and fitness. So the opinion cites RPC 84, which is an older opinion that provides that lawyers cannot negotiate away the filing of a grievance. We all have a professional obligation to follow rules, in particular Rule 8.3 on the duty to report. So the first inquiry and opinion was not part of the original request for an opinion, but it is a fact pattern that we came up with to remind lawyers about their professional obligations under Rule 8.3. The subsequent inquiries involved a lawyer serving as a mediator, and there are several of them. I'm not going to go through each opinion directly, but I'm going to summarize what the opinion says. So a lawyer serving.
Just a minute, Nicole. Make sure nobody has any questions as we start. Since number one is new, does anybody have any questions or comments about number one before we get rolling here? I don't see any hands. Okay, I'm sorry, Nicole. I didn't interrupt you, but now
That's okay.
that was a new piece. Let's get that out of the way. So now just roll on, please.
No problem. So lawyers serving as a third-party neutral are still bound by the rules of professional conduct, and it would be a violation under Rule 8.4a, which is the misconduct rule that says that a lawyer cannot direct or assist another to do what the lawyer cannot do. And so remaining silent in negotiating a clause that says that the lawyers and the parties will not report or any of the lawyers to the state bar is violation of Rule 8.4a by acting through another. The opinion also provides that it is conduct prejudicial to the administration of justice in violation of Rule 8.4D to include or communicate any kind of settlement agreement wherein the parties agree that no lawyer will be reported to the state bar. The opinion also explains that it does not matter if the mediator is verbally transmitting negotiation of this specific term, or if it is in writing when the mediator is going back and forth between the lawyers and trying to help them negotiate a settlement. So although the mediator does not require, or the mediator rules, I'm sorry, so the DRC has its own standards of rules that the mediators have to follow, and those standards don't require mediators to know the law applicable to the underlying matter or dispute to the mediation. However, our opinion says that lawyers are responsible for observance of the rules and to have a general understanding and knowledge of the rules, and lawyer mediators are not exempt from that. And that is required under preamble comment number 16. Again, the lawyer mediators do not have a duty to report the lawyers to the state bar unless the standards allow for them to make that report. And currently, the standards for professional conduct for mediators do not require lawyer mediators to report. So under 8.3E, lawyers mediators do not have a duty to report the lawyers to the state bar if they know that the lawyers participating in the mediation are negotiating this term, the prohibited term is what I've called it, that basically that they're not going to report any of the lawyers to the state bar. The opinion finally addresses any other obligations that the lawyer mediator would have, and namely that they have to inform the lawyers participating in the process and reminds them that we have a duty to report lawyer misconduct if we know that it raises a substantial question, and that the mediator cannot participate in the negotiation of a clause that would prohibit any of the parties or the lawyers from reporting to the state bar, and that if the lawyers insist on including such a term, that they would have to withdraw from the mediation. So the staff version of the proposed opinion has 7 inquiries, and you'll see in the materials that Ms. Kozlowski made some changes and some recommendations, and so her version has 8 inquiries. It's all the same until we get to number 6. So number 6, instead of including a fact pattern regarding what's happening in the mediation and the question, does the lawyer mediator have a duty to report the other lawyers to the state bar? The question, the facts are removed and there's just the question, does the mediator have a responsibility to report the lawyers to the North Carolina State Bar? The opinion remains the same. The answer is no, because Rule 8.3E provides that unless the standards for mediators requires a report, then no report is required. Number 7, the facts are what we took from number 6. So the parties don't reach a settlement at the mediation, but they did discuss the terms of not reporting with the mediator. They later go away and the lawyers come to an agreement on their own and they sign a written settlement agreement. The mediator subsequently learns about that written agreement. And then the question is, does the mediator violate the rules if they acted as a scribe by committing to writing at this prohibited term, not reporting to the state bar? And the answer is yes, and refers back to opinion number 2, which explains the professional obligations of a lawyer to avoid violating 8.4A by engaging in conduct through the 3 acts of another, and 8.4D, conduct prejudicial to the administration of justice. Their number 8 essentially is the same, except that the opinion deletes the part about informing the lawyers about the proposed terms violates the rules, and that the mediator must withdraw. So I'll let Tara explain why she wanted to delete that information, but there was also a footnote explaining that the standards of the mediator terms don't require that the mediators know the law, that they cannot give any kind of legal advice or advice about the underlining matter. But nevertheless, lawyer mediators are not exempt from following the rules of professional conduct. And that's my summary.
That's a pretty good summary.
Thank
Do you
you.
mind if I jump in?
No, Ms. Kozlowski, please go ahead. First of all, everybody just make sure they know who you are. Tara, will you sort of explain that, to make sure we're all on the same page, and then we'll be happy to hear from you.
Absolutely. My name is Tara Kozlowski, and I have a cold, so I apologize. I am the director of the Dispute Resolution Commission. So it is my job to take the commission's position and hold discussions with you wonderful people at the state bar and make sure that we are in alignment, because the majority of our mediators are also licensed attorneys. And so we do everything we can to make sure that our mediators are not crossing any lines regarding our rules and standards, as well as state bar rules and the rules of professional conduct. So that being said, Nicole and Brian know me very well. And I appreciate you all for being here today. Thank you so much for taking the time to reconsider this. One of the biggest concerns that the commission had regarding, let's start with the version that I redlined under what was opinion 8, in taking out that the mediator must withdraw. The commission is not opposed to the mediator withdrawing, but they just want to make sure that it is the commission telling the mediator to withdraw, not necessarily the state bar, because we've worked really hard to try to keep the hat on the mediator if they're a mediator and they're following the mediation rules, or if they're practicing as an attorney and keeping the attorney rules at the forefront. And we acknowledge that once an attorney, always an attorney. I'm an attorney, so I know my rules very well. But it's one of those things where we would prefer you need to withdraw in that scenario to come from the commission rather than the state bar. So we took that out, and I told Brian that the commission is absolutely open to doing an advisory opinion, giving practical advice, basically stating that if you're in a position where an attorney makes this recommendation, you cannot take that information back and forth. In fact, you need to tell them that if they insist on it, that you need to step back. We're perfectly willing to do that. But I notice in your latest draft under standard 7, it moves to, or opinion 7, it moves to may and should language instead of shall and must. So I think that would be sufficient, because instead of requiring the mediator to withdraw, it says may require. So there's a little bit of movement in that, that the commission, I think, would be more fond of. What other questions do you have for me?
One question that I've got is for those of you who are not perhaps mediators. When I took the mediation course some time ago, the best advice I got from a couple of mediators was, if you've really got any questions, just call Tara. Sort of like when I used to give people advice to call Alice or to call Brian or to call Nicole. That's just I think that's a rule of thumb for a mediator, for the mediator, whether they're lawyers or not. And explain, Tara, again, and everybody may know this, so this may be pedantic, but the advisory opinions that the commission occasionally propounds, the impact of those is what?
Right. So the advisory opinions are very much like common law. So the commission will take a question, and it's kind of like a formal ethics opinion that you all issue. And we hold those advisory opinions very dear to our heart, and a violation of those opinions is sanctionable by the grievance committee and the full commission. So once when an advisory opinion is issued and someone goes against the advice that is provided within that advisory opinion, and they are found in violation of the rules or the standards, then it's sanctionable not only by the rules, the standards, but also by failing to comply with the advisory opinion. And we have 43 advisory opinions currently on the books. So there's a lot of information within those opinions.
Great, thank you. So in essence, they are like FEOs but they are for They apply to all mediators, not just lawyer mediators. They apply to all mediators.
Correct.
Okay, thank you very much, Tara, and thanks for y'all's interest in your comments. Questions from committee members, comments, questions?
I have a comment.
Yeah, Bill.
I think from the DRC standpoint, an advisory opinion on the withdrawal would be very helpful. This issue has never come up with me in a mediation, and I hope that it won't, but it'd be a pretty awkward situation if it did, because I do want to be able to balance, the rules that apply to me as a lawyer, the ethics rules that would require reporting in some context, with my duty to continue with the mediation, because I understand there is an interest in keeping the mediator hat on and keeping the process moving forward if you can do that. So I think that advisory opinion would be helpful.
Yes, Fran?
I was just going to ask Tara if this comes up a lot.
No, in fact, this is the first time it's come up. We had a mediator that was investigated by the state bar a couple of years ago because she acted as a scrivener for a case, and this is what brought it to light. And I don't know if y'all know Maureen Robinson. She's kind of the history of the commission in my office. She's been there for 17 years. It's never come up. So this is the first go around, but it was such a fire that the commission is very concerned, and we want to make sure that we are keeping our mediators in line and that they are not crossing over and creating a situation where they're going to be in trouble, not only with the commission, but also the state bar. We do have an advisory opinion on the books about a family financial mediation where one of the parties was hiding assets, and they disclosed the information to the mediator. And the advice from the commission is that that mediator needs to withdraw, that they cannot proceed with the mediation because they know that one of the parties is violating the law, right? So that's kind of the way we view this. If it's against the state bar rules to transport this term back and forth, then the mediator must withdraw. And that's what I believe, if I have my magic 8 ball in front of me, what the commission will land on.
I'll also add, Fran, that the scenario of lawyers negotiating a settlement and including this term has been brought to ethics counsel's attention. I know the ethics staff has been asked that question. I've been asked that question a couple of times just over the past 12 months. And I was surprised that I was engaging in that conversation, trying to explain, no, you cannot negotiate away your responsibility under the rules of professional conduct. So that's where inquiry 1 is focused on, just, can lawyers do this? And we took this as an opportunity to clarify this, because it's one of those things I feel like every once in a while we come across kind of a norm that maybe is being questioned again. And so we wanted to make sure that this was clear and kind of stating the bar's position on whether or not lawyers can include in any sort of settlement agreement a term that prohibits the other lawyer or any party from reporting that lawyer to the state bar. So that's where it kind of starts off with opinion number 1, and then gets into the mediator context specifically based on what Tara just said.
Yeah.
Okay.
And
Yeah.
just to add to my prior comment, even though we've never had this problem before, almost every CME that I have taught since, I have told mediators, don't pick up the pen, make the mediators write down all the terms. Don't, be careful of this, make sure you're not in, violation of this. And I've seen a few people in the audience where their eyes are bigger than their heads, because I think that they are engaging in this practice just as a normal, good old girl, good old boy. Yeah, I'll put that in there for you, no problem. And I don't think they think about the fine details of it. So I think the formal ethics opinion coming down from you guys is really going to have a good impact on practice.
Other comments or questions? Nicole, let me ask you, the change that Tara highlighted from must to may. Can you talk to us about that?
I could talk about that, Nicole.
That's fine. That's fine.
This was a part of the change from the first draft of the opinion that was approved by the committee in April was not as much taking into account some of the different provisions, particularly in the comments to Rule 8.3. And so that's where you saw some of I remember reformatting the opinion, rewriting the opinion to really incorporate some of the language that you find in the comments, particularly it's comment 7 to Rule 8.3. And of course, there's that general, 8.3 dealing with the duty to report, but there's an exception under 8.3E that a mediator, if they learn during the course of a mediation, learns of information that might otherwise be reportable or compelled to report, they don't necessarily have to take that action because of their role as a mediator. But the comment goes on to say that, lawyer, we're trying to balance your different roles, your different responsibilities. And that's where the language you see there in the opinion that talks about not so much a lawyer must withdraw, a lawyer must or must not report anything like that, but to talk about a lawyer should consider withdrawing. It may be required to withdraw. And really the comment to 8.3 in kind of trying to flush out this balance of responsibilities, I think it kind of tips its cap to the recognition that mediators do have their own set of rules. And if the standards change that require reporting, then the rules as drafted would kind of, they would evolve with the standards changing. But right now, because the standards don't require it, then the rules too, just basically kind of set forth the exception as well as just the consideration that a lawyer might need to withdraw depending upon the circumstances. And so that's where we tried to kind of incorporate that language from the comments. And I have to say, just from our own ethics perspective, if somebody called about this, I feel like we would be pointing them to that language and probably encouraging them. Am I going to say you must withdraw? I don't know that I could say the rules require you to withdraw, but given the circumstances, you may have a very compelling reason. And sometimes I find myself advising folks, I would strongly, strongly encourage you to not touch this thing. So I think the rules, again, the rules try to, or especially the comment, tries to offer some flexibility, and we try to put that flexibility, that recognition in the opinion.
And similarly for reporting, Brian?
No, the reporting is pretty clear. I think the exception to the reporting is clearly set out in 8.3E. It's more so, what should the lawyer do? Should the lawyer withdraw? Can they continue on as the mediator if this sort of thing is being flushed out? And I think that's where, Tara, maybe we can talk about this in the opinion 7. The notion that the standards for mediators prohibit a mediator from offering, I believe it's just legal advice or other professional advice. And so, there's a kind of a consideration thrown in opinion 7 as to whether or not, a lawyer could inform the lawyers that are throwing this term around, like, hey, y'all, this isn't okay. This is a violation of the rules of professional conduct. I'm going to have to withdraw. I think that might be a potential point of tension between the opinion and what the DRC would have mediators do. It's my understanding, and Tara, I'd love to hear your thoughts on this, but it's my understanding that the DRC is not as comfortable with that kind of giving this, I don't know if you want to call authorization or a blessing to mediators to say, hey, what y'all are doing violates the rules of professional conduct, and I can't participate, because that might be giving professional advice under the DRC standards. Would that be accurate?
Yeah, I think so. And when Brian and I first kicked this around, he said, well, this is ethical advice, not legal advice. And I tried it. I took it back to the committee and they were like, no, not buying it. And so part of the difficulty is that no one has really defined legal advice. The commission looked at it a couple of years ago and we discovered what a hefty task that would be. And we stepped back really quick and said, we're just going to let it lie where it is. So we don't come across complaints often that are gray. Usually when someone complains that a mediator gave legal advice, it's pretty clear that it was legal advice. But the commission tends to be very cautious and narrow when it explains to mediators what they can and can't do. And so they're always going to say, don't say anything, don't explain why you're withdrawing, and just say, this mediation is not something I can continue with. I apologize, I must withdraw, and then withdraw. Now, there's always, the rules and then reality, and they don't always match. So if colleagues are colleagues, a mediator may very well pull somebody out of the room and say, what are you doing? I can't control that, but technically we tell them not to give any kind of legal advice, or the parties any kind of legal advice. And I'm afraid that if it was examined closely, the commission would come down with telling the parties that the term they want to include is in violation of the RPCs would be legal advice. So, but as long as you guys keep it under may and should, I don't think it's going to cross lines, because I think it's giving guidance from that standpoint, instead of being definitive and saying you can't do it because then you're in violation if you don't say these things. So I think that kind of keeps us in the clear, even though it's a bit murky.
Yeah. Well, I think that was that. I don't know if the subcommittee members have any opinion on that, but just this general notion of can a lawyer who is serving as a mediator have their lawyer hat on and say, hey, as far as your responsibilities on the rules of professional conduct, this isn't okay, or because they're a mediator, should they refrain from even offering that? Whereas if they were opposing counsel, they could reject it right then and say, that's a violation of the rules, I can't participate in that. Does that cross a line because you're serving as a mediator? Or maybe just the language, like Tara just said, it's really one of the options a mediator lawyer can consider taking, not a must, not a shall not. It's just kind of one of the options that a lawyer who's serving as a mediator can pursue, whether it's withdrawal, or whether it's saying to folks, this is something that's not okay. This is why I can't participate in this, because I think that's a violation of the rules of professional conduct. I guess it does get a little squishy as far as what is somebody supposed to do? What are they required to do? Maybe that's the thing. The opinion doesn't say what you're required to do, but it gives you some suggestions of alternatives, how to respond in that particular situation.
Right.
Well-
And then keep in mind that if the other party tells the mediator, oh, I can't agree to that term, that's against rules of professional conduct, the mediator is already in violation because they have transported that term.
Yeah,
Right.
let me ask one question here, and I don't mean did Fran jump off? I was going to give her a chance if she had anything.
Yes, she did.
Okay, okay. In the reporting situation, there is some latitude there that if you spot conduct and you bring it to the person's attention and they immediately correct it, or they, I've forgotten the exact language, Brian, but it says if this is aberrant, if it is and not the norm, and when you bring it to their attention, they go, oh yeah, I didn't realize that's that you don't have the reporting obligation. It was a DA. The example we had was a DA, or it was in a criminal case anyway. I can't remember the RPC or the FEO on it rather, but there's an out for reporting if when that you see conduct, but when you call it to the attention of the lawyer, they immediately correct it, and it is not in a pattern or course of similar conduct. And so if you were in the mediation and you brought up this term and the mediator said, I can't communicate that because that is something that is prohibited, and the person then says, oh, I didn't know that, I will drop that term. Do you know that do you know the scenario I'm talking about, Brian?
I do not. Nicole, is that sounding familiar? See, she's shaking her head no. I'm not remembering that one.
Okay. It's a bad thing.
I like that.
Sorry, I was muted. No, I'm not familiar with that either, but I'm looking.
Okay.
I like that. If it's possible, if it exists, right? And attorney A proposes the term and mediator takes it to attorney B and attorney B kicks it and says, we can't do that. And it's immediately fixed and no harm, no foul at that point. I think that would be fabulous.
And does Tara, you don't know me that well, but the people on this committee know that I do tend to sort of make crap up sometimes when I think it suits me. That's not what I'm doing here. I believe there is an opinion that says, this is not the way Brian normally operates. He did this. I went to him and said, you can't do that. That you're violating this stricture, and the attorney immediately corrects the issue and tries to absolve, sort of, get a do-over, expunge this is a reporting obligation. It is not.
David, I did find it. It's RPC 243. This is from 97, and it's basically talking about if a lawyer's conduct is an isolated incident, then it doesn't raise a substantial question about the prosecutor's fitness or the lawyer's fitness as a lawyer. And so they could potentially go and talk to the person about their conduct, but there's no requirement to report in that regard. And so so I think that's, this is getting into kind of the weeds on when is a report really compelled, and I know we sometimes get questions from lawyers about some pretty bad conduct, and they might just want to hear from the bar, yep, I think you have a duty to report, versus we're kind of on the border. I don't know if I would say it's a substantial question, especially like RPC 243 points out, if this is kind of an isolated incident, then it may not raise the substantial question. Whereas if it's a pattern, this person does this all the time.
Yeah, and I'm not thinking about this in the reporting context. What I'm thinking about is in Tara's nightmare scenario, where you have mediators that have no option, that as soon as this comes up to you, you have to withdraw from the mediation, but you're not really giving Bill a chance to correct his error by asking you as the mediator to take this to the other side, and Bill says, I can't do that. And
right, and that's what I understand. Tara, would you say in that scenario, lawyer provides mediator with this term, mediator sees it, and while they're not supposed to opine on the legal substance of the proposed terms, if they see that term that they know violates the rules of professional conduct, would you say the standards allow the mediator to even make that comment of, I can't bring this over to the other side, this is a violation of the rules of professional conduct?
Well, and see, that's the question of whether it's given legal advice or not. Right. And so that would be something that I would have to go back to the Standards and Advisory Opinion Committee to say, hey, look, is this something that we would allow? I always tell mediators to ask better questions than to make statements. So, hey, have you read the rules of professional conduct? That looks a little familiar, and point out the rules so the attorney can figure it out on themselves, right? But if there's a way that,
ethics advice,
right? But right. So it depending on how the question's asked, but I think that my better solution based on what you all just found is if the mediator unknowingly, because one of the big concerns from my mediators is we don't know all of the rules of professional conduct. What if we, there are some obvious ones, but what if we break one and we don't know it? If they're given the opportunity to take it from attorney A to attorney B and attorney B kicks it, and it's not back and forth, would that be enough of a correction where attorney A would not be reported on and mediator would not be in violation? Because I think that mediator saying no to attorney A is problematic. I don't know. I'm going to have to go back to the commission on that one and figure out how we're going to work through that.
And that's a tough thing.
Go ahead, David. That's much you can put on there, but it does, it seems like to me rather than having a knee-jerk response by the mediator that they must withdraw when this term, comes up in front of them, that they have a chance to, particularly if the commission has said you can't take this term and you must withdraw it rather than take it. If you pointed out the problem with that to the other side, it might save the mediator having to withdraw, which I know the commission would like to do.
Right. I mean, there's certainly a fine line, and I'd love for the mediator to be able to say, if you ask me to take that term across the aisle, I'm going to have to withdraw from the case, and I mean, fine lines, right? Is that giving legal advice? Is it not? Is it just, kind of foreshadowing? I don't know. I would certainly encourage the the commission or the committee at least to consider that as an option rather than having to walk away. In the advisory opinion I mentioned before with the family scenario, the mediator is given an opportunity to talk the party into rational behavior and say, hey, look, you're violating the law. I cannot participate in that type situation because you didn't disclose and whatnot. And so it goes through this whole scenario of how to back themselves out from it. And I would think that the best practice would be to provide a mediator a way to back themselves out of it as well without being in violation of our standards, because the goal is to encourage communication and promote conversation, not to have a mediator say, okay, peace out, I'm done, and run the other way.
Tara,
Yeah.
the mediator suggests that they contact the ethics council. They're not giving advice. They're just saying, this seems like it may be raising a red flag here, or maybe we should, have y'all thought about, and get the two lawyers together and say, hey, thought about maybe calling Brian?
That's actually a great idea, because the one thing we do tell our mediators is you can always tell a party that they have the opportunity to seek legal advice. Like, that's the legal advice that we do allow. So maybe that would be the solution, to just, have the mediator say, have you guys thought about calling?
I mean, that's what I do some mediations. Maybe I would just take the lawyers in the office and say, hey, maybe I need to make a phone call.
I think that would, everyone's got Brian and Nicole's phone number on speed dial. So at least I do. I think that would be a great option.
Other questions or comments from the committee? If do you think, Tara, at the I know the DRC is meeting in 2 weeks, something like that, sometime soon. Is this likely, would the advisory or would this discussion be on y'all's agenda?
I can put it there.
My question, I guess, and this is just, I feel, well, I'm just going to put this out there. If we held the opinion until there was guidance from the DRC on this, if there was an advisory opinion that came out before we issued this opinion, we could put it off until January is what I'm thinking. And then there'd be the DRC would have come down with it. And I don't know your time schedule. That may, I'm used to the state bar's time schedule. That'd be a little quick for us. But I mean, if it came down, there'd be something that, would give y'all the evolution that Brian talked about would be clear from the DRC, and then we could give more direct comment to the lawyer mediator that says you obviously got to obey what the DRC says you got to do, but here's also you got to obey what we tell you to do too. And that we now have clear guidance from the DRC. I don't know whether that's a good idea or not. I'm happy to take fire for that it is not a good idea.
I think it's a great idea.
Is the time schedule something that is a possibility, do you think, Tara?
So anything that we do, it has to be approved by the full commission, posted for comment for 30 days, and then adopted. I can call an executive committee meeting to adopt it faster than our next scheduled full commission meeting. So by January 10, it would be pushing it, but we could try. I think this is important, and I think that the guidance is needed. I have mediators now asking me about this all the time. And it would be great to be able to give them a definitive answer.
My boss is sitting around the corner here. Let me just ask Mr. Brown if he has any thoughts that he needs any wisdom, because he keeps a bottle of wisdom on the side of his desk. Do you have any wisdom you need to pour on us on this, Todd?
It is in great hands, so I have no wisdom to add. it's kind of confusing. There's certainly a tension there, but that's deliberate, it seems to me. So sounds like withholding it and getting some guidance is a good approach.
So one thought I have is, just based on some of the feedback, it sounds like there's the biggest tension is this question about providing legal advice, what the mediator can and cannot do. The opinion has more flexible language, and one aspect of this, or one alternative that we have not included in the opinion, is that the mediator could suggest the lawyers contact the state bar for ethics advice. So I think that would be something that'd be helpful to include in the opinion. I'm thinking maybe we include that along with what's already there as far as these alternatives. And again, the alternatives listed are not specifically saying this is what you shall do. It's just a you should consider, you may do this, because it really is going to be, I think, dependent upon the circumstances. How insistent are the lawyers? How responsive are they to perhaps correcting their conduct and so forth. But it's in opinion 7, that's where it's really coming from. So my proposal is we'll rewrite this ever so slightly to include a provision about contacting the state bar for ethics advice. I know Tara had deleted the footnote about whether or not this whole opining on the rules of professional conduct or somebody else's ethical obligations constitutes legal advice or what have you. That may just kind of muddy the water and be unnecessary. So if we remove that and include just, as another option, contact the state bar for ethics advice, then we may have at least a draft that is flexible enough, but still provides the guidance, kind of explaining where the lines actually are as far as lawyers not doing this, mediators participating in this, going back and forth, no, can't do that. And I know one of the opinions does remark on the mediator's lack of knowledge of the rules, and it comes down with the conclusion that ignorance of the rules is not an excuse. So, if you pass it along, yes, you have violated the rules. But it's also, again, clearly stated just that the reporting requirement is set out in 8.3E, that mediators do not have an obligation to report misconduct that they learn of during the course of the mediation, but that the mediator, him or herself, may need to withdraw, may need to suggest they contact ethics counsel, may need to just make a remark about this. I don't know if this is really on par with the rules of professional conduct. And if we get it in that format and send it over to Tara as kind of the new updated draft based upon the input here, perhaps that can serve as a launching point for your conversation, Tara, with your commission. That was a lot of words, but what do y'all think?
Comments from the subcommittee members? So is the proposal then, Brian, that we would rework this, the draft we have with the one addition that you mentioned about seeking guidance from the state bar, and that we supply that to sort of as a draft to Tara, and we see what the wisdom of the commission is when they after she's talked to them.
That's my suggestion.
Yeah, I think we should do that, because that otherwise we'll just lose it and it won't get done.
Is that what did that? Did you just make that as a motion then?
All I didn't say was I move so. I so move.
Right. We got a so mover who will second this for us.
I'll second.
Okay. Now further discussion. Or not hearing none. All those in favor say aye. Or raise your hand. Aye.
Aye.
Opposed? Okay. Well, Nicole or Brian, if y'all will make that one additional addition to the draft opinion, and then circulate it to us when you send it to Tara, then we'll put this. I would put this back on for the October meeting for a follow-up And if Brian or Nicole would get an update from Tara by the time we meet in a month, that'd be great.
Hey, David, can I ask a question?
Yes, sir.
This is just my trying to understand what's happening here. The footnote 1, I'm looking at, I guess, opinion number 8 now. Footnote's been deleted. I guess I want to understand. I assume Brian and Nicole put it in,
Yes.
and then Tara took it out.
Yes.
Can you help me understand first why you guys put it in? What was your objective in putting it in? And then Tara, why did you delete it?
We put that in because wanted to recognize I mean, that's the tension
That's right.
between the DRC standards. And it's based upon our conversations that we've had with Tara and others. So yeah, we wanted to just kind of, I guess, reiterate the point that yes, we know that this tension exists, but kind of taking the stance that whether or not this is prohibited is outside under the DRC standards is outside the scope of the rules of professional conduct. We're only focusing on a lawyer's duty under these ethics opinions, and a lawyer has a duty to uphold the integrity of the system, and that's why we're kind of even making the suggestion, despite it being potentially in violation of the mediator standards.
Right.
So that was the reason why we included it. Tara, I'm sure you.
Why you strike it, Tara?
Yeah, so I struck all the language that they proposed that the term violates the rules as well as the required disclosure. Because I'm in fear that the commission's going to come down that it would be providing legal advice and be in violation of our standards. So it's that fine dance of how do we allow the mediator to educate the attorney that the attorney is in violation of the RPCs without giving legal advice.
I guess I was thinking if you left the footnote in, would you be sort of getting at educating folks, because the mediator wouldn't have to say anything. It would be set forth in this opinion for people to read, and then it would come from the ethics committee, not from the mediator. It would be set forth in writing by the bar.
I suppose if they read it, yes, but my concern is that in real life, they're not going to read it until after they do it.
Yeah. And I think that's where I was looking at it and seeing that I don't know that it's needed. I think it's a helpful footnote. Frankly, I think it's very well drafted. But I don't know that I don't know that it's necessary, because we are still providing guidance on what a lawyer can or may do. And that's why I'm okay with removing it. It just, I don't know that it necessarily advances the ball other than highlighting the tension.
Well, here's my thought. I would like for us to consider whether or not we can use that in some educational fashion, in light of the fact that we're going to somehow put in Marcy's good suggestion of calling you. It seems to me both of those has a place, quite frankly, potentially. But I'm new to this, but it seems to me that footnote, we're always trying to educate folks, whether they read them or not is a different question, Tara, they're supposed to. We're always trying to educate our lawyers through these opinions, and that footnote seems to be getting at that in some respects. And now we're going to also add to this opinion the suggestion that we call Brian on the ethics hotline, another option. So just if there's any way to educate, I'm big on that. And we can maybe work some of what's in that footnote in connection with trying to say, call Brian if you have some of these issues. And maybe you can't, but just think about it. I see Marcy's hands up. She's probably going to tell me I'm silly.
No, honestly, I just spent 2 hours yesterday listening to these wonderful podcasts, Beyond Neutrality. Tara, you guys did a great job. Because mediators, David knows, I'm a mediator. Several of us are on this call. We have to do 2 hours a year to remain, to keep to our certification. And so these podcasts are great. So they do a great job educating. And that would be obviously something you can go ahead and make a note of. Tara, y'all can add it to your next podcast if you would like. But I think if you take the handcuffs off the mediator, which is so to speak, and let the mediator at least say, maybe we should make a call, and you guys may be shocked. I mean, you're signaling to them that there may be or may not be an issue. And I think that's great, because then hopefully you're going to avoid an issue that they could be going down a really bad place, and you're sitting there and you can't, and you want to stop it because that's the right thing to do, because they could be young lawyers that have no idea, have no clue, they don't read like they should read, and they're getting ready to do something really stupid. So not to allow the mediator a way to stop that train wreck from happening without giving them the advice themselves, I think is important. So I think it's just struck a great balance just for the mediator. And then you can educate the mediators and say, look, if you think there's a red flag here or something, you can take the lawyers in the room and say, hey, y'all might want to call Brian, call the state bar. So I think it does a lot. And I think education is extremely important, Todd. So I do agree with you on that. But they do a good job with their CME.
Sure.
Well, and I think the mediator, if it got to that point, the mediator could say, I think we just need to take a break here. And you guys ought to consider calling the state bar.
That's exactly right.
Because
before I listened to this stuff today, that's exactly what I would have done. I might have done something wrong. I don't know if I would have done anything wrong, but to me, it's common sense. I mean, it just.
Well, yeah, and we have the authority to take a break.
Yeah.
Declare a break. So.
Yeah.
So one thing that I don't know if we encourage it, but I know that when people call and ask, that we don't discourage, is we tell mediators that they can provide information, but they can't apply the facts of the case to the information, right? So if this RPC is published, it may be that the mediator can provide them a copy of this ethics opinion.
Yeah.
Right? Or I'm sorry, not RPC, but this ethics opinion is published. Right. That the mediator may be able to set this in front of them and say, I'm going to go to the bathroom, read this, and you figure it out, right? Because they're not giving legal advice, they're just providing information, which is kind of what we have stolen from the AOC, because they tell their court staff and clerks that you can provide information, but you can't apply the facts to the information.
That's fair.
Yeah, that's good.
Once this is published, right, with the advisory opinion, that may in itself resolve the situation. Even though I still want just go call Brian and Nicole in there, because I love them.
Yeah.
We all do.
Brian and Cole, they might like the idea of giving them a piece of paper instead.
Yeah, I was going to say, we're going to say email ethics staff, not call Brian at 919.
Since Suzanne isn't here, call Suzanne.
Yeah, we'll put Suzanne on there.
I can tell you this is a real issue. I had a lawyer call me just a month ago, and they were in a mediation. I don't know if it's the same one, Brian, that you got the call from or not. And the lawyer was calling me going, the other side is wanting to put this in the agreement. I said, oh, no. And she said, this doesn't sound right. And I said, no, it's not right. Do not participate in that. Do not. So, I mean, yeah, so it's out there.
Well, I can tell you on behalf of the commission, we really appreciate you all taking the time to work on this. We've definitely had it in the works for a while, and we know you've spent a lot of time on this, and I'm super pleased with it, and I really appreciate you all very much. Thank you.
Well, and thank you, Tara, for y'all's interest. And I did not mean to put the spur to y'all about trying to get this done, but I think it would be helpful for us if we had if we could. We're happy to hold off for a while and see if we can get coordinated on the things. I think both halves of the House are helpful in giving instruction to the lawyer mediators. I think that's great. Well, we need to vote then, folks. So if there's been a motion in a second, is there further discussion? But you still got about a minute and a half by my watch for somebody. I got a good story, but I think we've already voted to do this. So is there anything else that anyone needs to bring to our attention?
No.
All right, very good. Thank you. We're through early. Make a note of that, Nicole and Brian. We're through early, and we'll see all
by
of the
2 minutes. Thank you all.
and the staff. Thanks, guys.
All right, take care, y'all.
Thanks, everyone. Have a good day.